Your time right now, 7:32. Tomorrow, a Lexington County courtroom becomes the next battleground in the Alex Murdaugh double murder retrial as attorneys square off over a series of different motions. And today we are talking with criminal defense attorney Taylor Bell about what we can expect tomorrow and about some of the key legal issues that are going to be brought up. Thank you for joining us this morning.
Thanks for having me.
All right, so a lot has happened over the past couple of days in regards to motions. So what can we expect tomorrow, and what will be, in your opinion, the main focus?
Well, I think the first motion is the motion to dismiss the indictments, which is based on alleged fraudulent testimony to the grand jury in order to obtain the indictments by, I believe it was SLED Agent Owen. There was a previous case several months back in which a circuit court judge dismissed indictments. Now, just because the indictments got dismissed in that case doesn't mean that the government can't go back and re-indict the case. However, I highly doubt Judge McCaslin will dismiss these indictments based on the allegations of fraudulent testimony before the grand jury. I think that testimony relates to the blood spatter and physical evidence, the allegation that they had matching ammunition that was found at the residence, which matched the ammunition used in the murders, which was not true. I think that is what the motion is based upon. However, I would highly doubt that Judge McCaslin would dismiss those indictments, just given this case has already gone to trial. However, it is new information based on evidence and information obtained during the first trial, which was unknown. But it just seems highly unlikely that those indictments would get dismissed. So I think that's one of the first things that will be argued about. Next, I think they're going to argue over venue, where the actual trial should take place. I believe there is the proposition by the defense that the trial is to take place in Charleston. I think there was information submitted by the defense that Charleston could accommodate this type of trial. There is a much larger jury pool. Now, at the end of the day, the argument is not, or the basis for a juror to sit on the jury is not whether they've ever heard of the case. It's whether or not they can be fair and impartial with the information that they may previously have. So I think that's one. I think there is a motion based on the DNA, the unknown DNA underneath Maggie's fingernails that the defense wants to have independently tested. They're going to assume they're going to argue over that. And then who is going to independently test that, the capabilities, how much DNA there is, whether or not there's enough sample that it will all be destroyed, or there's enough that it can be used and preserved. I think there's a motion to use Alex's own testimony.
Talk about that. Yeah, I've never seen that before in a trial here.
Well, most of the time we don't have two trials.
Right.
So, but I think it will be admissible. He's previously testified under oath to the facts related to this case. I do believe they will be able to use that because it is a statement that he made related to this matter. So I believe they will have the transcripts and will be able to use his testimony in this matter. At the very least, if he were to testify again to impeach him, if he says something different in the second trial, that is, if he takes the witness stand in the second trial.
I found
lots of unknowns.
I found that to be very interesting about using his own testimony against him. Does that kind of give an idea into what the state's strategy is going to be going into this new trial?
Potentially. So I look at it this way. If an individual sits down with law enforcement prior to an arrest, those statements, if they are lawfully obtained, not coerced, and law enforcement follows the proper procedures, to obtain those statements can be used against you. The rules of evidence allow a statement by a party opponent to be used against that individual. And so I think that they, I relate it to that scenario. So if someone gets up and sits down with law enforcement, confesses to something, that statement can be used against them. And many a times it is used against them. And in this scenario, he sat down and on the witness stand and told his story. He also sat in the vehicle originally before he was arrested, and those statements were used, those video footages were used in the first trial. And essentially what they're going to try to do is show inconsistent statements. So he said this first time when he took the witness stand, the second time he said this, to show that he's not telling the truth, essentially, or at least that he's told multiple versions of events.
I want to talk a little bit about exactly what's at stake at this pretrial hearing. I think we have video from when he had his last pretrial hearing, but let's talk about, for people who may not realize how important this particular pretrial hearing is going to be. What is the goal of it, and could the judge make all decisions at this pretrial hearing, or is there potential for another one?
I highly doubt she'll make rulings on everything. A lot of decisions which are evidentiary, what evidence is admissible in the trial, a final ruling generally will not be made until that evidence is sought to be admitted by whatever party wants to admit, because most of the facts have not been put into the record yet. So therefore, the judge might not necessarily have enough of a basis to make a ruling. For example, I think there's a motion by the government to discuss prior bad acts, the financial crimes. Now, we know from the Supreme Court opinion that they have said that must be limited, and that was one of the basis basis for the new trial, or part of the basis which they laid out that was, in violation. It went too far. Well, that decision I don't believe will be made until we have testimony, until the government. Now, there may be some limiting instructions given by the government, but a final decision will not be made, because you have to lay the foundation to enter that type of evidence based on testimony that's entered as evidence at trial. So I don't necessarily believe a final decision will be made on that. I think that a lot of those evidentiary type issues will be held off to, and a final ruling will not be made until we're in trial.
Okay, so so many questions that still need to be answered as this continues to unfold. Thank you so much for breaking down a look into what we can potentially expect to see tomorrow in the courtroom. And you guys, we know so many of you have been following this closely, so we're going to put this on our website, WLTX.com, so you can check it out as you prepare to watch. And don't forget, News 19 will have full coverage of everything that is happening in the courtroom from gavel to gavel tomorrow.